Our next witness is law professor Eugene Kontorovich, who can explain Panama's treaty obligations and the remedies the U.S. might seek for potential violations. Professor Kontorovich is appearing virtually, and Professor, you're recognized for your opening statement.
Chairman Cruz, Ranking Member Cantwell, honorable members of the committee, I appreciate and regret the opportunity to testify before you remotely. I've been asked to discuss possible violations of the treaty concerning the permanent neutrality and operation of the Panama Canal entered into between the two countries in 1977. I should say at the outset that determining whether a certain situation violates the treaty is a mixed question of law and fact, depending on both the meaning in the treaty and the actual situation on the ground. I have not had any classified intelligence briefings on this subject, so I'm going to speak about the meaning of the treaty primarily. We shall see that under international law, each party to the treaty is entitled to determine for itself whether a violation has occurred. Now, in exchange for the United States ceding control of the canal, which it built and maintained, Panama agreed to a special regime of neutrality. The essential features of this regime of neutrality is that the canal must be open to all nations for transit, that's Article 2, equitable tolls and fees, Article 3, an exclusive Panamanian operation, Article 5, the prohibition of any foreign military presence, Article 5. Article 5 provides that only Panama shall operate the canal. Testifying about the meaning of the treaty at the Senate ratification hearings, the Carter administration emphasized that this prohibits foreign operation of the canal as well as the garrisoning of foreign troops. Now, Article 5 appears to be primarily concerned about control by foreign sovereigns. If Panama signed a treaty with the People's Republic of China, whereby the latter would operate the canal on Panama's behalf, this would be a clear violation. But what if Panama contracted for port operations with a Chinese state firm, or even a private firm influenced or controlled in part by the Chinese government? The Suez Canal Company was itself, before being nationalized, a private firm in which the United Kingdom was only a controlling shareholder. Yet this was understood to represent British control over the canal. In other words, a company need not be owned by the government to be in part controlled by the government. So the real question is the degree of de jure or de facto control over a foreign sovereign company, and scenarios range from government companies in an authoritarian regime, completely controlled, to purely private firms in an open society like the United States, but there's many possible situations in the middle. The treaty is silent on the question of how much control is too much, and as we'll see, this is one of the many questions committed to the judgment and discretion of each party. Now, turning to foreign security forces, the presence of third country troops would manifestly violate Article 5, but this does not mean that anything short of a People's Liberation Army base flying a red flag is permissible. The presence of foreign security forces could violate the regime of neutrality, even if they're not represented in organized and open military formations. Modern warfare has seen belligerent powers seek to evade international legal limitations by disguising their actions in civilian garb. From Russia's notorious little green men to Hamas terrorists hiding in hospitals or disguised as journalists, bad actors seek to exploit the fact that international treaties focus on sovereign actors. Many of China's man-made islands in the South China Sea began as civilian projects before being suddenly militarized. Indeed, this issue was discussed in the Senate ratification hearings over the treaty. Dean Rusk said informal forces would be prohibited under the treaty. Thus, the ostensible civilian character of the Chinese presence around the canal does not in itself mean that it could not represent a violation of the treaty if, for example, these companies and their employees involved Chinese covert agents or other agents of the Chinese security forces. So this leads us to the final question: who determines whether neutrality is being threatened or compromised? Unlike many other treaties that provide for third-party dispute resolution, the neutrality treaty has no such provision. Instead, the treaty makes clear that each party determines for itself the existence of a violation. Article 4 provides that each party is separately authorized to maintain the regime of neutrality, making it a separate obligation of each party. The Senate's understanding accompanying to ratification also make clear that Article 5 allows each party to take, quote, unilateral action. Senator Jacob Javits, at the markup hearing, said that while the word unilateral is abrasive, we can, quote, decide that the regime of neutrality is being threatened and then act with whatever means are necessary to keep the canal neutral unilaterally. I look forward to their questions.